And let's take another look at today's development, talking about the suspension of the CJN. I'm now being joined on the news at 10 by a senior advocate of Nigeria, Mr. Norrison Quakers. Thanks a lot for joining us on the news at 10.
My pleasure.
What a day, you know.
What a day.
NBA, PDP, Third Force. Well, you know, when we talked about it the last time, you talked about respect for the office rather than, you know, the individual. So did you see this coming?
Yes, I will say this to you. I'm not surprised that it has happened. And this is not the first time. History is merely repeating itself. Under President Goodluck Jonathan, it happened to Justice Salami. The heavens didn't fall. And now it's happening to the incumbent Chief Justice of Nigeria. Now, what is my own take on all of this? Now, I've been hearing from some quarters that the president suspended the Chief Justice of Nigeria. Constitutionally, the president does not have such power to suspend the Chief Justice of Nigeria. What the president has done is to merely act on an order of the Code of Conduct Tribunal, which was obtained ex parte. Now, my worry is this. Against the backdrop of the order of the Court of Appeal, which is a supervisory court over the Code of Conduct Tribunal, having made an order to stay proceedings until the issue that has been placed before it is determined. In the face of that order, an order has now been made by the Code of Conduct Tribunal, signed by 2 members. Now, constitutionally, they ought to be 3. Now, I've seen a copy
so was
of
that a quorum? I was going to ask.
Well, it's a quorum because 2 out of 3. They did form a quorum because the law says 3. Now, 2 sat and the order was now made. Now, the wordings of the order is also very apt and very clear. It was directed at the president, and one is to the Chief Justice himself to step down, and then an order mandating or directing the president to swear in the next most senior justice of the Supreme Court in the hierarchical structure of the Supreme Court. Now, that comes within the purview of Section 231 sub 4. Now, when you look at the provision of Section 231 sub 4, because we had also referred to this a while back, it enables the president to swear in the next most senior judge in the event of the absence of an incumbent or occupier of the office of Chief Justice of Nigeria. So now you could say the president has given himself some constitutional cloak to so act. But legally speaking, there's no way the president can suspend or remove. Section 292 is very apt and clear as to the removal of the Chief Justice of Nigeria. Now, because he's the head of an arm of government, that's why you have that provision there that it can only be removed by 2/3 majority of the Senate. Now, how can that also happen? You also have the National Judicial Council that is responsible for his removal. So
before you talk about that,
yes.
Is he properly before the CCT? Because, you know, people say, well, that's beside after the fact, you know, he's already been suspended. But that argument is still out there to say, yes, everything at the CCT applies, but not before.
It's not properly before the CCT. And that's the essence of the preliminary objection on jurisdiction that was filed by Chief Wolola Nipwekun, leading a team of senior advocates, to the extent that the CCT has no jurisdiction to try the person of the Chief Justice of Nigeria, not because it cannot try a judge, but in the person of Chief Justice of Nigeria, in relation again to his being a judicial officer. Mind you, some have also argued, if you look at the provision of Section 290 of the Constitution, in relation to the filing and submission of Code of Conduct forms, now, it is in relation to judicial officers. When you look at the administering of the oath of office and oath of allegiance as a judicial officer, it is clearly stated there that as a judicial officer, you will abide by the Code of Conduct.
Okay, so briefly now, some people say there's a corruption angle, and there's some other angle, but looking at it, looking at the cultural angle, some people say, all right, since the second person who has been sworn in is from the north, it's a political thing, and perhaps he has not done nothing wrong. So wrap it up for us briefly and say, has something been done wrong? Something
certainly has been done wrong. And the way to also look at it is that, you know, we're currently in a polarized environment. Any step being taken by the president will be misconstrued. And I think that the advisors of the president should also advise him correctly. by and large, I also go further in saying that the Nigerian Bar Association, this is the time for us to now begin to discipline our members. Mind you, first time the president came on air said he is not aware and that he didn't know that the Chief Justice of Nigeria is facing criminal prosecution at the Code of Conduct.
Well, he's now aware.
And that is also an embarrassment. Okay, now he's aware. Question is, what do we do? If our members take a matter to a court where the principle, where the issue has been laid to rest, to prosecute or ventilate, it's time for the Nigerian Bar Association to now begin to discipline our members for doing such, because it's an embarrassment. Now, from the look of things, if we're not careful, this can snowball into major crisis, and it will cut across. I've listened to the PDP spokesperson, what he has said, and a number of persons have also spoken because of the sensitive nature of what we have on ground. Whether the Chief Justice is corrupt or not, there's a laid-down procedure to follow. And until that procedure is followed, what you just be doing is you create a state of anarchy.
Interesting times for the judiciary indeed.
Certainly.
Senior Advocate of Nigeria, Mr. Norris Quakers, thanks for giving us that analysis on the news.
My pleasure. My pleasure.